Thank you, Your Honor, and may it please the Court. In connection with a public issue or an issue of public interest, that is the statutory phrase that the Court is called upon for the first time to interpret. And it's the criterion that determines what's called prong one under the Anti-SLAPP Act, whether or not a defendant who is sued on the basis of speech or conduct in furtherance of freedom of speech can bring a motion under that statute, and nothing more. That's all this is about, is prong one. It does not determine the outcome, whether the plaintiff can prevail. That occurs under prong two, where the plaintiff would need to make a showing and demonstrate a reasonable likelihood of being able to satisfy all elements of its claim. If you'll allow me, I'll quickly state what are the petitioner's responses to the three questions posed in the Court's order granting cert. Number one, yes, Colorado's anti-SLAPP statute imposes a nexus requirement. That is implicit in the statutory phrase, in connection with. And I'm sure we'll be discussing how that is satisfied in a moment. Number two, yes, the Court should apply the same criteria it has used in other freedom of speech contexts to determine what is an issue of public interest. And then finally, three, no, a speaker's motive for or reason for disseminating speech that is in connection with an issue of public interest doesn't and shouldn't play any role in determining whether prong one of the anti-SLAPP statute has been satisfied. Turning first to the nexus requirement.
Mr. Zansberg, can I jump in and
Yes.
say good morning to you? Just want to figure out where the issues are joined here. And if I'm understanding it, I'm not sure that you disagree, the sides disagree on the first two questions. It seems like you agree there's the nexus requirement, which is focused on in connection with. And I think there are concerns about the division going further than that, and we could talk about that. But I think both sides agree on the nexus part, and I think both sides agree that the proper test, whether it's the same test as defamation or not, is the RAND test from the California, I think it's the Supreme Court, maybe the Court of Appeal. Am I wrong about that? I'm just trying to figure out where the parties are disagreeing.
I believe you're correct, Your Honor, that both parties agree that, number one, that there is a nexus requirement. We may disagree about how that's satisfied. Number two, I'll let counsel speak for himself, but even though they embraced the RAND formula from California, and we said we're fine having this court adopt that as well, we actually believe matter of public concern is an issue that this court has previously articulated aside from California's precedents, but there's no material difference there. The RAND factors provide some guidance for what is a matter of public interest or general concern. Counsel or Tender Care has argued that matter of public concern is different than matter of public interest, and we don't agree about that. But so there is disagreement on that point.
At least on the first issue, it does seem that by the time the dust settled in the briefing, everybody was talking about RAND and embracing that. And I think Judge Daley, in his opinion, sort of starts from there. He doesn't cite RAND, but he cites the three criteria, and then he goes on to talk about facilitating public debate, right, which I gather both sides are saying isn't really part of the test. Is that fair?
I think that's fair. And RAND, by the way, came out of Rivero. And it's been incorporated many times. It's part of Philmon, and it's part of Geiser versus Coons. But that the tripartite test about whether the person is the subject of the discussion is a public figure in the public eye, whether it affects people outside the particular interaction that is discussed, and whether it's just generally an issue of public interest. Those are helpful guideposts that we agree that if this court adopts them as part of its jurisprudence, can assist in deciding the question of the second part of the statutory phrase, what is an issue of public interest? It's not, Rand doesn't talk about the nexus. So there are two parts, right? Nexus and public interest. And Geiser versus Coons, the most recent decision from California Supreme Court, says that phrase has two components, at least with respect to the provision it's in, E4 here. And so matter of public interest, that's what it has to be. First of all, the statement has to implicate in a reasonable way, in an objectively reasonable way, any issue of public interest. And I don't think there's any dispute there either, as the Court of Appeals below recognized that, discussing the quality of medical care by a licensed facility offering its services to the public is unquestionably a matter of public interest, as is a business open to the public accommodation mistreating its customers, and whether or not it's falsely advertising itself as a 24-hour facility. All of those are legitimate questions of public interest, no matter how you pose it. But it doesn't talk about the second prong under Kuhn, whether or not the connection with the nexus.
Right. So let me make sure I'm understanding it correctly. The nexus requirement imposed by the division here is really judicial gloss that doesn't find any sort of origin in the statute or First Amendment precedent. So there really, if I'm understanding it correctly, there is no nexus requirement. We just look at those three criteria and apply those, and ultimately what we're here about is disagreement over application of that tripartite test, as you put it. Is that a fair summary?
Respectfully, no, Your Honor. We concede that there is a nexus requirement.
Okay.
That the statutory phrase "in connection with."
Oh, I see what you're saying. Yeah.
So there are
the
two
nexus
elements.
requirement,
There's
right?
both a matter of public interest. If there's just a purely private dispute between neighbors that over their fence or something like that, that's not a matter of public interest.
Fair enough. But it's not facilitating public debate, right? So.
Right, but the facilitating public debate, we think the court's actually order very accurately stated what it means to have that nexus. The court stated that the nexus requirement demands a defendant's speech encourage, facilitate, or contribute to a general debate or public discussion of a public interest. Any one of those three, and the reason we embrace that formulation is because encourage it could be the first statement in a set of postings, as here, that then encourages others to share their views. And, the amici say anytime anyone posts to a website devoted to consumer reviews, the Yelp amici brief, but also TripAdvisor, Health Grades, the Better Business Bureau, ripoffreport.com. Every day there are more and more sites devoted to this, to consumer review.
Mr. Zandsberg, good morning. How about Nextdoor?
I'm sorry?
I'm sorry. How about Nextdoor? That's the neighborhood, posting about things happening in your neighborhood.
Right. I think there are, and here the community fora in which, in addition to Yelp and Google and TenderCare's own Facebook page on which our clients posted these were community fora like Nextdoor that are devoted to sharing information among members of community for the benefit of that community and for the public interest. And so the guys are...
I'm sorry, I just want to go back for 1 second. But so are you saying we look to where it was posted? I'm sorry.
No, it's me.
No, it's not you. Trust me, it's me. I'll make a point of speaking up. So are you saying we look to where something is posted to apply the second part of Kuhn? Is that?
Yes. In what Geiser versus Kuhn's informs is that those same factors of content, format, and context are relevant to both Step 1 and Step 2 under California's approach for Prong 1. So Step 1 is it a matter of public interest? Does it implicate reasonably any matter of public interest? And there's no question about that here. The nexus part, Step 2, you also look at content, context, and format. And context includes where it's published. And, a good number of the cases that deny any connection.
I'm sorry, where is a place that content would be published that wouldn't be public? I mean, I grumble to my neighbor, I guess.
Yeah,
But
outside.
Anything other than that meets that criteria?
Well, the case law tells us that private communications or communications limited to an extremely small group have a higher bar to satisfy encouraging, facilitating, or contributing to the general debate. Philmon held that a communication to a limited group of business entities, and Dun and Bradstreet held that a credit report to 5 subscribers who were bound by confidentiality not to disclose that was not a matter of public interest because of that limited distribution. So yes, I think there are instances where the context, a private email between 2 individuals, is very different than posting on Yelp and all of those other community fora, and particularly consumer review websites or Better Business Bureau.
But it does matter. It's not just, that's certainly a relevant factor that it's on a public forum. But that's not dispositive, right? You have to look at the individual statements. And frankly, this is at least a question I had about here. There's a lot of statements. And correct me if I'm wrong, but I don't think we just look at all the statements as a package. We have to look at each statement, do we not? So some statements may be relevant hypothetically. This particular company is providing terrible service and may harm your pets. Be careful is one thing. I'm going to get even with these people is a different thing. Wouldn't you agree?
I would agree that they are different, but as a general rule, under defamation law, and the civil jury instructions say so, the court considers the publication as a whole. No statement is to be reviewed in isolation and wrenched from the context, overall context. Here, whether the overall context includes the entire chain of emails that are in the record is a question that courts have disagreed about. But within a single posting, say Appendix A and B to the Court of Appeals decisions, a single posting on the Google reviews for Tender Care or Tender Care's own Facebook page, yes, those are different statements. But and I also agree, Your Honor, that merely posting something onto a public website does not render it a matter of public concern. Not everything people post online is a matter of public concern. There are purely private matters between individuals that don't have any, under the RAND factors, have any likelihood of influencing or having any interest to people outside of that transaction, or they may not involve anyone in the public light. But here, all 3 of the RAND factors are satisfied. There can't be any serious question that maybe I'm going to get even with them, or she's rude, she's narcissistic, or whatever it is. Those statements, also not actionable, they may not be as much of public concern as the other statements are, but you look at the publication as a whole and determine whether or not the RAND factors or this court's other precedents determining what is a matter of public interest and concern are met.
I understand. And so let me just feed back what I think you said, or summarize back. If we have one statement that one posting, and there's a bunch of different statements in there, we look at the posting as a whole. If there's an independent statement, say there are 5 different posts, and we could feasibly say those are different. We look at them individually. One of them might not have to do with the public interest, and the fact that it's just on a public forum does not necessarily make it a matter of public interest. Right? We can assess it that way.
That is, you've stated it more eloquently and accurately than I.
I don't know about that. Just making sure I understood. Thank you.
Mr. Sandsberg, good morning.
Good morning.
So tell us from your point of view, where did the division go wrong? What did they get wrong here?
The primary error was to elevate what the division considered the motivation of the speaker to defeat the remainder of the applicable test under, well, Geiser versus Coons. And as a matter of fact, motivation, as we've argued, really should play no role whatsoever in assessing whether or not prong one has been satisfied. Coons makes clear that a lot of information about public interest arises out of personal experiences, sexual harassment in the workplace. And this court's precedent in Kemp and multiple precedents indicate that the motivation of the speaker does not in any way determine whether or not the substance, the format, context, and content of the speech addresses a matter of legitimate public concern.
And your position is that not that the division gave too much weight to motivation, but that they consider it at all. You're saying it's irrelevant for purposes of this particular prong, correct?
That is correct. And, I think in that regard, maybe I think having reread the amicus briefs, they probably do a better job of it than we did in our briefing. But the speaker's motivation, if it's relevant at all in the anti-SLAPP context, is relevant in prong two, not under prong one. And what we, I think, argued well is that the primary interest of the anti-SLAPP statute is to protect speech that does encourage, facilitate, or contribute to general debate about matters of public interest. And again, whether or not that speech is actionable and can be sanctioned is a prong two issue. And it's helpful to note that there are multiple cases, including one cited by the Court of Appeals, the Hayworth versus Pino. I mean, multiple plaintiffs have succeeded under prong two, including, Hayworth versus Pino is a review of a medical practitioner, and it was found to be a matter of public interest under prong one, and the motion was denied, as it was in Piping Rock Partners versus David Lerner Associates. It's cited in the amicus brief. We didn't cite this, but that case on page 6 of the Public Citizen and Public Participation Project's amicus brief, that was a ripoffreport.com review, and of not medical but of real estate, and was found to be of interest to the public because it was a real estate firm doing business with the public. Turns out it was a completely fabricated review. The person who posted it had never had any business with that. It was a personal vendetta, and there was proof that it was completely fabricated. And what do you know? They got to go forward with their claim under the anti-SLAPP statute. And so... Was that analyzed at step 1 or step 2? Well, it was analyzed as... it was accepted as... it was both. I mean, it was found to be a matter of public interest, and in connection with a matter of public interest under California and our statute, but it was found to be sufficiently actionable. That's true here in Colorado, too. We have Rosenblum versus Bud, a completely manufactured website, was found to survive prong 2. Coomer versus Donald J. Trump, and Coomer versus multiple Coomers from Dominion Voting Systems, and the statements were found to be on matters of public interest, not surprisingly, and those claims continue. If our clients had said that Tender Care had murdered and mutilated their chimpanzees, and they have no chimpanzees, and they never brought them to Tender Care, and they hadn't been murdered, that would be a matter of public interest and concern. But it would also be an actionable claim. And Mr. Zandsberg, so if the statements were, I just want to exact revenge and put this company out of business, and everything is sort of along those lines, does that still survive step 1? I'm sorry, is your question if that's the only thing that was said? Well, I mean, let's say that there were, 50 things said, but they were all sort of that sort of nature, right?
exact revenge, put out of business, horrible business, put out of business.
Without any recounting of why those statements were being said?
I'm trying to figure out where these lines are, right? So let's start there. Yes.
All right. If I think if someone just said, I want to put this company out of business, whether it's Target or any company, and didn't offer any reason for that personal vendetta, then that would likely not be a matter of public concern.
Okay, and so I think the line is the second somebody starts to describe what it is that they are unhappy about. So sort of more subject matter in terms of the source of the complaint. Then you get through step one.
Yes, and here again, obviously I'm an advocate here, but I don't think this is a close case. We can look at the outer edges, but where our clients are talking about their own experience with a licensed medical facility open to the public, and are sharing that they've spoken with dozens of others who've had the same horrific experience.
Well, I'm asking because whatever we write won't just
I understand.
apply here.
Right. And I acknowledge that there are matters of purely private interest that don't affect a lot of people outside of that transaction. I think the RAND factors are very helpful.
And then when we look at motive, just to tie this up, so your position is motive does not apply to the public interest. It may apply to the second, and I take it might apply to the second if we're looking at malice. Or yes,
no, it's all right.
If we're looking at malice, for example, when we get to the merits, whether the plaintiff has a likelihood of succeeding, a bad motive may show they acted with malice, for example.
I won't get into the extent to which bad motives play into a finding of actual knowledge of falsity or reckless disregard of the truth. But yes, all of that motive is the stuff of prong two, not prong one. Yeah. I'd like to reserve the rest of my time, if I may.
You may. I'm also going to ask the bailiffs if they are able to draw the blinds. The folks who are standing at the lectern are under an interrogation lamp. Thank you. Thank you.
I don't know, Chief, we may be giving Mr. Havens an advantage. We had, we had to sign a spotlight in your face, too.
You feel nice and cool. Madam Chief Justice, Your Honors, may it please the Court. Not everything said in public serves the public. This Court should affirm the decision below for two reasons. First, the anti-SLAPP statute requires a functional connection between the speech and a public issue. And second, in determining the content and context of the petitioner's statement, the Court of Appeals correctly considered the petitioner's motive in making those statements. My first point as to the nexus requirement, it seems that there is little to no disagreement amongst the individuals in this room as to whether or not there bears some level of a nexus between the speech at issue and whether it's connected to a public issue or an issue of public issue of public interest.
Mr. Havens, can I stop you? Can you lift up your mic just a tiny bit? So, yeah, I want to make sure we can hear you. Thank you.
The respondent's position is that the nexus requirement, in addition to naturally, as laws do, imposing a nexus between means and ends, here it imposes a nexus between the speech and the public issue or issue of public interest. What necessarily determines the degree of that connection? And given the purpose, given the plain language of the anti-SLAPP statute, it's respondent's position that there must be a functional connection. It is not enough to merely say something along the lines that refers or relates to or has some other word that describes a tenuous relationship between the speech and a purported public issue, but it must be such that it pushes forward public debate. It at least encourages public debate, makes an offering to the public, provides them with information that is, to some extent, helpful or provides guidance.
Can I ask you, Mr. Havens, and good morning to you, put a little meat on that bone. I mean, what's the test for that? What exactly does that mean? I mean, the statute talks about a statement in connection with public interest. And you've said functional connection, you've said a whole bunch of things, advancing the public debate. I'm not sure what that requires. Could you help me?
I apologize for interrupting you.
No.
It would require a statement that on its face appears to engage in public discourse, right? The statement that Dr. Smith didn't follow CDC guideline and protocols during flu season this year, right? Leaving many individuals, including myself, subject to risk. Right? I fear that this is a safety issue. That statement is providing information to the public, right, for them to work with, as opposed to.
I interrupted you. Finish. I'm sorry.
As opposed to, Dr. Smith almost killed me in his hospital today. Right? Don't go there unless you want to die on the hospital room floor. The difference between those two statements, I feel, at least that example, is glaringly apparent to the reader as to the former providing information that is helpful and useful to the reader, whereas the other is more vindictive, inflammatory, doesn't really give the reader any context or accurate information from which to base a decision on that could affect the public.
That seems to be a pretty high bar, though. Somebody says the doctor almost killed me, avoid him, would seem to be something the public might be interested in. And then you could ask why, but how is that not a matter of public interest?
What value would it? I don't mean to respond with a question, Your Honor, but
sure.
I think that the court would need to look at what value does that information provide to the public, right? If the statement is merely inflammatory of the doctor almost killed me, without any substance or information from which the reader can look at that and say, here's the potential public interest or public issue, right? Here's the issue with what the doctor is doing or the regulated professional is engaged in, without any information from which the reader can look at and say, that's something that I need to be aware of, other people need to be aware of.
Why is it be careful enough?
I'm sorry.
Why isn't it enough to essentially warn someone to be careful without elaborating on exactly why? And I'm sorry.
No, you're good. I was going to ask the same question.
Without any substance as to why the reader has no...
Because it provides the public with some encouragement to be more circumspect in dealing with this particular physician in your hypothetical, right? I mean, that's...
Certainly, Your Honor, but in the same respect, it disparages the party against who the complaint is made.
But isn't that the problem with including motivation in this part of the analysis? Is I think that then pretty soon you ignore the public interest and you get stuck on motivation, right? You're right. The motivation may be the person's upset at that doctor. But if the person's saying, hey, I went to this doctor and I almost ended up dying, and I, on the other hand, I'm looking for a doctor in the future, and I look at that review, that's helpful to me, even if the motivation by that patient may have been because they were upset or whatever reason, right? That still is something that's helpful to me, isn't it?
That is based on the assumption that the statement is true, Your Honor, right? There's no shortage of statements that are on the internet that lack any truth or veracity to them.
Sure, but that goes to why doesn't that go to the second prong? Right. And what a concern here, and why I was asking about the test, is it seems like, okay, so you need to say more facts about why I almost died, and where's the line? How many facts are enough? And it seems to me you have a compelling point, is if it's not true, the plaintiff is likely to succeed in that case. That would seem to be second prong.
Yes and no, Your Honor. The proving actual malice is a difficult test. Even proving the reasonable likelihood of actual
proving
malice.
It's false. This woman never even saw this doctor, as the case that Mr. Zansford pointed out. That would be pretty easy to prove.
By clear and convincing evidence, Your Honor, I doubt that many people who post online reviews are taking written notes or having other conversations saying, here's what I'm going to go do, and post with knowledge that is not true or with reckless disregard as to its truth. I think the proposition, I don't disagree with my friend's proposition that motivation certainly should be considered on the second part, particularly as it relates to actual malice. I frankly cannot think of a bona fide reason by which we would ignore motivation on the first prong, particularly if the goal here is to weed out the meritorious claims from the non-meritorious. Not considering the motivation on the first, not considering motivation on the first prong appears to almost turn the anti-SLAPP statute on its head, in that here is a procedural mechanism granted to the defendant that the legislature has enacted in order to balance freedom of expression with people that have meritorious claims. The initial burden is on the plaintiff. Show us that this is an issue that falls within the 4 enumerations of the statute. There is nothing that's going to look to the veracity of the plaintiff's statement other than whatever they said. The truth is assumed, and there's no doubt about here's what it is. Let's look at the statement. If that's a public interest, that's a public interest. It is not too difficult to make any statement you want about anybody and say, man, interest rates are high, right? And at that point, you satisfy prong 1. Now the defendant says, it's on you. Show me actual malice with clear and convincing evidence, flipping the statute on its head, making the plaintiff have to bear the entire burden of essentially proving their case at a time in which sometimes they didn't even have discovery yet.
Yeah, so I'm playing devil's advocate with you here a little bit, but my concern is on your test, we really shut down speech. So you're right, there's a balancing. We want to protect public interest. We want to protect people like your clients, in a situation where they're truly harmed by a defamatory statement. We've got to balance that. Your test would seem to shut down speech. I mean, the plaintiff or the speaker needs to be thinking, have I said enough? Have I provided enough facts? I'm not sure I can speak. I may be liable here. And that's troubling to me. So, what's my question? I suppose, take your hypothetical. I saw this doctor and I almost died. You said that's not enough. What else does the person have to say?
How did you almost die? I think would be a good place to start, right? The name of the doctor, the situation you're under, how it personally, there's no shortage of personal experience that the reviewer or consumer or whatever situation can share with the general public.
But the problem with that would be, okay, I saw this doctor and I went home and I got exceptionally sick and I was bedridden for a week and I almost died. Don't see that doctor. And I could see somebody coming back, but you haven't explained why the doctor caused that. Maybe you just got COVID independently. And then we get into that morass. We're at a motion to dismiss stage here. We have to accept the factual allegations as true for purposes of the motion to dismiss. And so I guess I worry about requiring too much. And why shouldn't prong 2 do the work that you're mainly concerned about?
I got two responses to that, Your Honor. I think the factual scenario that you provided may not even be actionable unless it is the implied assumption of here's this doctor and because I was there, then I got sick. There's really no attribution in your hypothetical, but I don't think people that enjoy posting reviews, I don't think they have any reservation about putting more information out there. And I don't reasonably foresee individuals putting reviews and having to wage with themselves whether or not here's enough information, here's not enough information. I think that the line is drawn pretty clear when it goes from my doctor almost killed me, right, to my doctor also committed fraud against me, right? Things that are completely unrelated to the transaction itself that tend to serve no benefit to the public but only relate to the personal experience, right? The personal experience always comes first. It is the relation of how that information goes to the public interest is what the respondents contend should be so essential in considering whether or not the speech is made in connection with that public issue or interest.
I hear what you're saying, but I think there's a meaningful distinction between receiving professional services from a physician, a veterinarian, where there may not be a sophisticated understanding of exactly how things went wrong. If I go to a restaurant and I have a bad experience as a layperson, it's not difficult for me to maybe elaborate on that. If I take a trip and I have a tour guide and I post something on TripAdvisor, it's easier for me to articulate that. Under the test that you're articulating, I wonder if that doesn't impose too much of a burden on regular folks who are just trying to explain the experience they had.
I think that in large part, Your Honor, the explaining of the experience is typically in the form of an opinion, right? The assertions of fact as to, for example, out of this case, right, that fraud is being committed, right, that somebody's elderly father who's an owner of the veterinary care is using his power to intimidate customers from reporting things to DORA or what have you. It is those specific allegations that are the issue. Consumer reviews for things like food, goods and services, in my experience, or at least in my rationale, are very seldom going to be an assertion of facts such that it is, here is this crime that you committed, right? Because what we're dealing with here is defamation per se. This is not per quad where we're still trying to show actual damages and how this hurt them in the community. The allegations here are based on purported crimes that were not committed. So it is a bit simpler in this case, but as far as consumer reviews, travel reviews go, I think that the majority of them are grounded in an opinion, right? It is when you start to attack primarily, right, the principles of those entities with specific allegations of wrongdoing is when, the test really should be able to weed out what is meant to serve the public, right? What is meant to give the public information from which they can use and make informed decisions, as opposed to, here's something bad I want to say about this guy, and the way that the Colorado law could purport to be, right? He's not going to be able to do anything about it.
Well, let's focus on, go ahead.
Let me ask it a different way. Give us an example of something that is okay and then something that crosses the line, so that we can, instead of hypothetically, give us a concrete example of okay and cross the line.
Was the medical example earlier not clear enough?
No, apparently not, because I'm asking the question.
Sure.
What I'm trying to do is compare it to, where does the line, where do we cross the line?
When does it stop being too conclusory, I suppose? Is that?
Yeah, I just want an example.
Yeah.
Sure. I think that when you say when does it cross the line, when does the line cross from here's a information that is helpful to the public as to this is only related to the personal experience?
Right. Where do we cross the line into the public interest?
It would be based on allegations of personal experience that seemingly have no relation to the service itself that's being provided. Right.
Give me an example.
I can give you the example. The example here, Your Honor, would be they have complaints being filed against them with the labor board for withheld pay, amongst other serious charges, record at 4. The nature of the statements here, or the public interest, is supposed to be veterinary care, right? What are these folks doing with it relates to the animals? What are the standards that they're employing? Do they have licensed professionals to do the work? Whereas here, this comment goes to, are they abiding by the labor practices that the state of Colorado has mandated?
But it would be okay if they would have just said they're terrible veterinarians?
Well, that would have been a statement of opinion, Your Honor. Yes, I frankly, if that's all that the statement was, yeah, that would be a protected statement.
Okay, so because it's, okay.
So let me ask, I'm still struggling. So maybe let's talk about that. Let's talk about this case. So you gave the example of the father or father-in-law is, exerting pressure on us and making threats and the like. And again, I'm not assuming any of that's true. Why is that not in the public interest? That the business practice of this regulated entity, if this were true, is to use these kind of tactics. You should avoid a company that uses this kind of tactic. And again, second prong says if it's false, it's not protected. But why is it not in the public interest to say this regulated entity uses this kind of tactic?
I think under your hypothetical, Your Honor, that may be a permissible statement that might touch on the public interest, provided that there is some means or mechanism to the plaintiff in the case in order to ascertain that at the outset, without having to say we need to show by clear and convincing evidence that this, having to prove the absence of threatening behavior or sexual assault is extremely difficult on its own. There's never a paper.
But are you not arguing that the statement is not protected because it's not true? And I wasn't asking a hypothetical. You gave that example as one of the statements at issue here. There's an allegation about tactics by your client's father or father-in-law.
Sure.
Right?
Right.
And so my question is, why is that not it may be true or not true. That's a different question. But why is it not related to the public interest that this regulated public entity uses this kind of tactic?
It could be related to the public interest, Your Honor. I think the point that I am trying to make is that if we say carte blanche without looking into the motivation of the speaker and making the statement, everything is going to be a public interest. Everything will be a public interest. I had an interest today in how much it was going to cost me to park when I came here, and I guarantee that's something that people that park in that parking lot share as well. The point that I am trying to make is that this is a procedural mechanism that was put in place in order to assist defendants in these type of cases. The statute is a balance between the right to expression, but also recognizes that there are meritorious claims, right, that may touch on an issue of public interest or concern, but that are still hurting businesses across the state. By removing the plaintiff's ability to look into the motivation of the speaker, why that thing was statement, what could happen, what's the truth behind it, by removing that at the first prong, everything is going to be considered a public interest, and now the plaintiff is going to have to meet a exceedingly difficult burden as far as what they need to prove by clear and convincing evidence, or else they have nothing else. Their case is going to be dismissed with prejudice, and they're paying attorney's fees.
Well, let me push back a little bit on you on this. So let me give you an example. Say the only statement, and Justice Birkencotter asked this question of Mr. Zansberg, the only issue was, I hate these people and I want to put them out of business. That would not be in the public interest if that's the only statement, and that may be motive or whatever else, but there's nothing in the public interest. That's just pure vendetta, as opposed to, this is the business practice I've experienced. Why is that not a fair dividing line? I mean, when you're talking about, here's my allegation of how they do business, regardless, bad vet service, they didn't take care of my pet correctly, they engage in this kind of practice, they make threats about billing. That all are factual allegations. They are allegations, I'm not assuming the truth of them, that relate to the public interest, it would seem to me, different than just a pure statement of vendetta.
I agree with you, Your Honor, right? But I think the issue with that in the anti-SLAPP statute and the formulation that the courts have developed is that if we assume those facts as true, there is no first prong, right? Everything is going to be considered a public interest. Every business in the state of Colorado, whether it be by the state or by a county or municipal level, is regulated in one shape or form. So every business now knows that anything that's said about them, whether owner committed sexual assault against me, these guys ripped me off, they beat me outside. A consumer can say anything they want because people have bad service and sometimes will say things that are out of bounds, but in the moment when you're angry, it feels good to get it out. They can say whatever they like, knowing that because that's a business, that's going to be a public interest, and all I have to do is just wait for them to rack up attorney's fees in order to prove clear and convincing actual malice. I think that flips the statute on its head, and it doesn't strike a balance, which is the main purpose of the statute, in protecting the right to expression, but at the same time recognizing that some of these claims for defamation are meritorious.
Don't you agree that their burden at prong one is fairly light? I mean, it's not a heavy burden, right? It's not a heavy lift that they have at prong one.
No, yes, Your Honor. I agree with you that it is not a heavy lift, and I think that given the discussion with Justice Gabriel, if the prong is to be held, if motivation is out of bounds, totally improper, outside the realm of consideration, then it's a cakewalk at that point. I think.
But I mean, Justice Gabriel just gave you an example, right? If the comment on Justice Birkencotter too, if the comment is just, I hate these people, or I want to put them out of business, or sometimes you see reviews where, maybe just give a thumbs down or a 1 star without explaining anything, or, just don't like them or didn't have a good experience. I can see those as not being enough to qualify, to get past prong one. But when you have, going back to the hypothetical we were talking earlier that you brought up, went to see this doctor, got treated by him, and almost died as a result. I mean, I see that as different because you're providing your experience about this particular physician that you went to, that you got treatment from, and that you ended up having an extremely bad experience with. That would seem to me to be in the public interest, to be something that the public would be interested in.
And I think that you are correct, Your Honor, but I do not think that by looking at those allegations, we need to accept them as true, as if it is a 12b-5 motion, right? I think that the special motion to dismiss can come, and I'm likely mistaken, but it's, I believe, up to 90 days or 70 days after the filing of the complaint, correct? So there is certainly time that can go on after this, but to say that we're just going to assume this is true, you got to take what's posted on Yelp. That's the statement. You can't look into it. You can't see what he was doing that day. You can't see who he talked to about the statement before he made it. To impose that on a plaintiff under the special motion, under the anti-SLAPP statute, I think just flips the statute on its head. I think it's a principle of fundamental fairness that both parties bear burdens. There's a balance in the statute. To say that motivation is completely off limits for whatever reason.
Is your argument that motivation, then, if you can prove some motive behind it, you were upset, whatever, then that means they're untrue and they're out?
I think that the motivation, Your Honor, is going to inform the court whether or not it's a public interest, right? The content of this, or the context of the speech is informed, not only by where it's said or who it's said to, but it's also by what was the speaker's motivation in bringing it. Right? There's a difference between how are you and how are you. Right? The tone doesn't translate across an internet page, Your Honor. And so, to the extent that there's issues with a particular test for the nexus prong, I think that so long as motivation of the speaker can be considered in determining whether or not the issue relates to a matter of public interest or a public issue, will rectify any issue with that connection.
So how would it play out in this hypothetical? A person posts something that says, I went to a particular doctor, they provided horrible, horrible service, I almost died, I hate these people and want them out of business. So you have a really motive of anger here, but they've stated facts that would show public interest. How do you weigh that? There's maybe a bad motive with some facts behind it, but now there's a vendetta because of what happened to them. How do you weigh that? Is that not protected?
I think at that point, Your Honor, I think you're past the first prong. I think at that point you're in the second prong looking to see, is this something
But you said motive is relevant to the first prong, so I'm giving you a hypothetical where there's a motive of anger and vendetta along with a statement of public interest. What do we do then?
At that point, I believe that the current case law, at least in California, at least maybe in unrelated anti-SLAPP cases in Colorado, is that so long as there's some, not scintilla, but a reasonable person by looking at it can see that there's a issue of public interest within the statement, notwithstanding whether or not there are what seems like private grievances there, then that satisfies the standard as far as a public interest, and we move on to the second prong.
So then it sounds like you're saying motive is irrelevant if it's clearly a matter of public interest. That's what I'm trying to figure out, right? You said motive is relevant to the first prong, and I'm figuring out how. How do we weigh that when we have both a bad motive and a statement of public interest?
Because unless the plaintiff can see motive on the first prong, it won't know whether or not there's veracity to the statements, whether or not it is something that is actually founded in truth and being put out there in order to assist the public or inform the public, or if it is just flat-out falsehood, Your Honor. That is where we get to. The public interest standard, I believe, is where the only remaining disagreement lies in this case between the parties. The RAND factors, not expressly applied in the decision below. Nonetheless, my friend on the other side has said that they satisfy, or at least that they are helpful, and they would not, they condone or consent to the adoption of it. I think that there is a independent reason, other than we all agree it's a good test, to have those factors imposed for the second prong of the special motion to dismiss. One being, we're at a completely different point in the litigation. We're at the outset. At times, discovery has not been completed as opposed to the full merits determination. Second, and candidly, right, the determination of what constitutes a public interest, reasonable that someone would have a legitimate expectation in the information. People love information. I think that the test currently for public interest in defamation and invasion of privacy cases is amorphous in the sense that it's really hard to pin down what information the public wouldn't want, right? Considering particularly the day and age that we live in, we are in the information age. We have, encyclopedias at the tips of our thumbs. I think it is reasonable to assume that any, valid argument can be made as to, here's something that happened to me, here's why other people in the public would want to know about it. The categories from RAND, I think, limit the breadth of what is currently characterized as the matter of public concern test, in the sense that it gives at least not necessarily a new rule, but guiding posts to the courts below. One of the biggest foreseeable issues that I could see with the anti-SLAPP statute is, if the matter of public concern test taken at whole from defamation and from invasion and privacy cases is what's considered for the second prong, I think that a lot of inconsistency with the courts is going to be arrived, because while it is being decided as a matter of law, there are certainly facts that the court needs to find in order to determine whether or not it is within a matter of public interest. And I think at the very least the RAND factors as guideposts with the matter of public concern test as a backdrop provide the lower courts at least some level of guidance as to is the second prong satisfied? Because, again, the balance here is meritorious claims and right to expression. And to the extent that one judge interprets matter of public concern, it means something completely different than the other. A party with a meritorious claim may end up losing out on something that's bona fide and that's something that they seek to rectify.
Well, and applying the Rand factors here, looking don't the statements here pretty clearly satisfy the second that it's a matter that could directly affect a large number of persons beyond the immediate participants?
I disagree, Your Honor. No. The first one being, does the statement concern a public figure or a public entity? I'm focused
on the idea that it could directly affect people with pets in the community. That's the second Rand option.
Sure. Could the statements concerning veterinary care, tender care, affect others in the community? I think that there's a reasonable argument to say yes. 8 of the 37 statements that were referred to in the Court of Opinions appeals are referred to in the Court of Appeals opinion. That's what relates to tender care's veterinary operations and procedures. The rest have nothing to do with veterinary care at all. I have a group of folks who are talking about wanting to go to court and deal with this clinic once and for all. They're going to wish they had never tried to bully me and my family. I can't think of a person that would look at that and say, oh, that's information that I need that may affect me if they're going to go to court, or that they're going to bully her with her family, or that they have labor complaints purportedly lodged against them.
But isn't it the problem with taking it piecemeal and looking at each sentence separately? You have to look at the whole thing in context, right? You have to look at it as a whole. And when you look at it as a whole, then you get the message is clear, right? They're very disappointed in the service they got. They have questions about the type of practice that place has, and they go on beyond that. And sure, some of it may reflect a motive of anger, but a lot of it is information that if somebody's looking for a vet in that community, they're going to find helpful.
I disagree, Your Honor, that the statements need to be looked at as a whole in the context, right? I mean, certainly there may be a situation where facts allow for that, but at least as it pertains to this particular case, I do not think that going and looking at the entire context is in the interest of justice here, right? While we can say here's certain statements that relate to veterinary care, if we look at the context, that allows for they're the biggest scam to ever walk into town. They're not only incompetent, but they're cruel. It's a joke of a clinic. I have never witnessed such blatant ignorance and lack of training in my entire life. Your proposed analysis allows all those statements to be swept under the rug because we're looking at the total context. So I think that
for purposes of prong one, right? We're just at prong one. We're just trying to figure out, do they get past that first prong?
Meaning at the first prong, should we look at the entire context?
Right.
I fail to see how that would merge over into the second prong, and we wouldn't still be looking at the entire context, Your Honor, if that makes sense. Ultimately, the anti-SLAPP statute is meant to be a shield and not a sword, and I think that the argument and analysis for how the anti-SLAPP statute should operate after today's case that's proposed by the petitioners would tend to flip the statute on its head. There's no longer be a balance to be struck. It would be a completely favored statute for the defendants in defamation cases. Thank you.
Thank you. Mr. Zansberg, you've got 7 minutes and 44 seconds.
Thank you. I'll try to hit a few points in rebuttal. One is the argument that the difficulty of proving actual malice or any element of a plaintiff's claim is a reason to not fulfill the purpose of the anti-SLAPP statute and turning the case on its head. I'm frankly lost. First of all, the anti-SLAPP statute does provide for discovery before a response is due, much like under Rule 56F. That's in 1320-11016, allowing for discovery, particularly if actual malice is at issue. One would think one would want to take discovery. I do want to also, though this wasn't specifically raised, I want to get back to a question Justice Samore asked me about the biggest mistake. at the court below. And I believe it is first motivation defeating matter of public interest. But second, paragraph 30 of the decision below makes the mistake of suggesting, or holding, I should say, that unless the statements specifically reference this issue of broader public interest, I'm quoting here, veterinary diagnostic issues, shortages in or access to veterinary care, oversight of veterinarians, general quality of care of animals outside large cities, or veterinarians' lack of training for the care of smaller dogs, or how overbreeding can cause health problems, blah, blah, blah. And that is not the test, and never should be the test. In the first instance, there were many statements that clearly called into question the competency of this particular group of medical practitioners, not any single one, as well as their quality of care for animals, et cetera. And, you know, it's quite clear that Geiser versus Coons, the statement at issue was, come on out, you cannot hide. That was the sum total of the protest outside of the landlord's home. And the court said, from the context, we understand that that was addressing broader issues of urban redevelopment and unethical foreclosure practices, what have you. So it's simply wrong. I would say that was the second biggest mistake, is to require a specific reference to a broader public issue. And it's pretty clear that most of the comments on consumer review sites don't do that. And we would thereby subject all of consumer reviews that talk about people's individual experience with medical practitioners or businesses would not be available able to assert an anti-SLAPP motion, again, which they could very well lose if, in fact, they speak in actionable terms. To address Justice Boatwright's question about examples of speech relating to the practitioners of tender care that may have no relationship to the public interest. The defendants or others could say they don't mow their lawns, or they have terrible taste in clothes. I mean, the list goes on and on. Things that have nothing to do with their dealing with the public as licensed medical practitioners.
Well, Mr. Zandsberg, what I'm struggling with is the 8 of 37 point that opposing counsel made. The 8 of 37 point that he made about, in his estimation, 8 of the comments going to operations. And so I do struggle with your argument that as long as much of what's said is rooted in the public interest, you need to look at the overall context. And Justice Samore followed up on that. And I understand there may be some value in that, but I struggle with how you draw the line around someone who gets upset legitimately about something, or seemingly legitimately, and then they go on to say something that is defamatory. You know, I hear that this physician abuses his wife, or says something that's not rooted in fact and is just somebody sounding off because they're upset. Would your argument be that even this physician abuses his wife is still part of it and shouldn't be actionable? And if not, then how do we draw that line? When is it? That's clearly more incendiary than this person doesn't mow his lawn, right? But help me with that.
Yeah, I think each case needs to be evaluated on its, on its merits, and looking at the context, content, and format of the speech in total. And I'm not sure where 8 out of 37 came from. I know it came from the Court of Appeals, but I don't know where they came. They haven't identified. There was no delineation of 37 statements. That there are 100 some odd counts in the complaint. So I have no.
I get hung up on the math.
Okay.
Yeah.
But yes, the physicians there beat their wives, or they sell drugs, not through the clinic, but on the side. That may well be a matter of public interest. People may not want to do business with folks who are engaged in illicit and illegal conduct. But I don't where to draw that line as opposed to what's before the court today. how practitioners dispense medical care to patients and of concern to others in the community who have pets. And in terms of I'll move to the next point I wanted to make about spurring public discussion of those issues. The court has the benefit of hindsight and looking at what actually occurred. The court did so in Geyser versus Coons. The protest prompted the target to issue a press release, and that satisfied prong 2, that it actually did spur public discussion. Here the evidence is overwhelming, the number of responses and public comments about others saying, yeah, I had a similar experience. I'll never take my pet there again. Thank you for telling me this. This is going to save lives, et cetera, et cetera. There's no question whatsoever that this prompted, facilitated, and contributed to public discussion of issues of public interest, how a licensed medical facility provides that care to members in the community. And I would just also point the court and close with the quote from on page 29 of our brief, the Great Wall Medicine PC versus Levine case out of New York, 2022, where the court says the statements at issue were published on public websites such as Yelp, ZocDoc, and Facebook, and they concern the defendant's experience with plaintiff's medical practice and accuse plaintiff of unethical billing and medical practices. The reviews are clearly intended as a warning to other women so that they are not scammed in the same way. Thus, the statements fall under the anti-SLAPP law because they were posted in a public forum and were made in connection with an issue of public interest, namely the integrity of plaintiff's medical practice. And I think that should guide this court's decision, and it should reverse the Court of Appeals.
Thank you. The court thanks both counsel for their arguments. This case will stand submitted, and the court will be in recess until 10:15.